Reid and Dassey trial transcript day 7, page 118. We'll back up to this line here on 117. Dr. Gordon's testimony no longer becomes relevant, and thus it misses on the first step, the first prong of the test of whether or not it should be used in this case. I'm not going to recede from the ruling that I handed down before. I think what we have at best today is testimony that doesn't go to the admissibility of anything Dr. Gordon has to say. And again, what Dr. Gordon is, as I understand it, going to testify to that based on a number of tests that he administered this defendant, based on the age of the defendant, based on the defendant's limited cognitive abilities, that this defendant falls in the category that scientifically has been adjudged as being a category of persons being more suggestible or vulnerable to saying things that aren't necessarily true. I think that Dr. Gordon's testimony is still relevant. I think that he is a qualified expert. I think that his familiarity with the Gudgeonson suggestibility scale and the other tests that were given to support whatever opinions he's going to give are all as good today as they were before. Now, with that said, it may be, again, that while his testimony is, sir, I believe admissible, it is up to the jury as to what weight that testimony should give. They are the persons that determine the weight. I also find that I do not believe, based on anything I've heard today or during the course of the trial, that his testimony would be superfluous. Accordingly, I'm going to deny the state's motion to exclude his testimony. Attorney Kratz: Judge, I don't mean to take issue with the court. You mentioned that the doctor would testify to being vulnerable to saying things that weren't necessarily true. I think that's exactly what the court said he could not testify about. He's vulnerable to suggestibility, but whether it's true, the court, Attorney Kratz, or not true is something this doctor cannot testify. The court, right, and I did say that, and thank you. I'll sharpen that up. He can't testify as to what this defendant said as to whether it was true or false. He can testify as to the suggestibility, the vulnerability, based on the factors, but he cannot utter an opinion as to the truthfulness or falsity of anything this defendant said. Attorney Kratz: Thank you, Judge. As to my second purpose for all alerting the court as to the state's intent with this court reaffirming its ruling, the state does intend to and does offer at this time two rebuttal witnesses. One is a clinical psychologist who will directly rebut Dr. Gordon's testimony as to the testing IQ and what opinions may be drawn therefrom. His name is Dr. James Armentrout. We previously meaning earlier today, I don't mean to indicate because of the rebuttal nature that it was other than today, but informed defense counsel of our intent to call Dr. Armentrout as a rebuttal witness. But secondly, Judge, and something that we have alerted the court and counsel to earlier, was our intent to call an expert in the areas as to the interrogative process. This court may recall, as part of Dr. Gordon's offer of proof, Dr. Gordon indicated that he was not an expert on issues of interrogation strategy or circumstance, but that such experts do exist. Dr. Gordon conceded that fact to both in court and on his DVDs. The suggestion and the effect of the matter is then, as to the area of suggestibility, there is a prong, if you will, as to the testing and the IQ and the age and the vulnerability to suggestibility that psychologists talk about. But the other part of that Dr. Gordon talked about was the circumstances surrounding the interrogation, the strategies and the like that were employed, and what, after reviewing a specific interrogation, what opinions can be drawn therefrom. State intends, as the defense and the court knows, to call a Mr. Joseph Buckley, the president, as I believe, of Reid and Associates, author and expert on issues of the interrogative process. With the court having reaffirmed this ruling, we simply offer that. If the court needs or the court wishes some further offer of proof or sharpening of that particular Mr. Buckley's relevance or his intended testimony, we can certainly do that. A report has been tendered to the court and to the defense as to Mr. Buckley's intended testimony. If I could have just a moment here, Judge. And Judge, you may want to just take judicial notice of the report of Mr. Buckley that has been provided to the court, should Mr. Buckley's testimony be allowed. We'll certainly have that marked as a trial exhibit and will be officially offered at that time. That's all I have as to, again, just by way of alerting the court and counsel as to the state's intended rebuttal case. Thank you. The court. All right, does the defense wish to be heard on this now? Rebuttal, of course, is at the discretion of the court, and it may be you want to wait until you hear what Dr. Gordon has to say, although I suspect Mr. Buckley's rebuttal may have as much to do with the cross-examination of Investigator Wiegert as it does with anything that, that Dr. Gordon may say. Attorney Freeman. Up to the court. I don't think that Dr. Gordon's testimony necessarily is going to be indicative of what our position is with Mr. Meade. Or Buckley, I'm sorry, Mr. Buckley. The court, yeah, Attorney Freeman. Our essentially, and let me first answer the first comment about Dr. Armentrout. The only thing I would ask from the state, if at the time he testifies, if there is any sort of summary of his impressions laid to some written form, that we be provided a copy prior to his testimony. Whether that be the second he sits down, however the state wishes to provide it, would be great. Also a CV, I mean, we provided our curriculum vitae of our doctor. If we could have Dr. Armentrout's sometime before he testifies, we would appreciate that as well. However, as to Mr. Buckley, we have three essential positions as to why we don't think it's relevant. Number one, it's not a unique subject that this trier of fact, the jury, needs assistance to understand. In fact, they've had two witnesses already talk about it, both detectives. Detective O'Neill and Investigator Wiegert have testified that they are trained in deceptive practices, superior knowledge, whatever language is used to explain why they lied, promised, led, or suggest to a interviewee in order to get information or extract information they want. So it's a point, I won't say necessarily cumulative, but it certainly has been developed and addressed by the state. It also seems to be somewhat of a vouching of the state's witness. Mr. Buckley would be testifying essentially that the officer's testimony, that this is how we're trained and this is just simply an interview technique, would be an offer to simply vouch for the veracity of the officer's testimony in that regard. And we also believe that there are some comments in the report about what is corroborated and what is not that impedes and infringes upon what this jury's role is. And the attorneys can certainly suggest to the jury, this is corroborated and this is uncorroborated, and that's fine. But I think it's different having a witness get up there and say, I've reviewed what the police officers did in this case, and let me tell you, jury, this is what they did right, and this is what they found, and this is why you can find this person guilty. I don't think that is the role of an expert. Experts should be offering some sort of testimony that, number one, has to be relevant to some sort of material issue, which we don't think necessarily is, that there is enough with this offer as of yet, and number two, we certainly have to say there is nothing that indicates that this trier of fact needs assistance to understand that. In fact, I believe in opening, Mr. Kratz mentioned to the jury comments about officers questioning and why people don't admit to things that they didn't do, especially as serious as a homicide, because it's just human nature. You all understand that, quote unquote. That was what Mr. Kratz said to the jury. Well, if they understand it, then why do they need an expert? So I don't think it's necessary. The court. All right, Mr. Kratz, getting to you with respect to Dr. Armentrout, counsel was asking for a copy of his CV and as well any sort of summary that you might be able to supply, even if it's at the 11th hour. Are you able to accommodate him on both those counts? Attorney Jones. Well, Judge, there is no written report, there is no summary. Dr. Armentrout's opinions will be based solely and entirely upon what's been provided by Dr. Gordon. So the materials that Dr. Armentrout will be drawing from, they already have. The CV is something that I will ask to be faxed, and we'll try to get that. Here, Judge, and accommodate out of courtesy the defense. Did you ask me something else? The court. No. Attorney Kratz, forgotten. Then I'll be quiet. So it was an error earlier when the report said Attorney Jones, which I thought, but I read what was there. The court, no, we'll get to the issue of what, if anything, Mr. Buckley can testify to based on, in part, what we hear tomorrow, and in part, I want to review the report again. Report was handed, I believe I got it on Friday from the state. Attorney Kratz, might I suggest, Judge, that on Wednesday we might convene in court, perhaps at 8 a.m. and get some direction. We expect Mr. Buckley to testify in the morning, and I think that is probably appropriate that everybody, not just the state, but that the defense has fair notice about the scope of what he'll be allowed to testify about. The court, that's fine. Attorney Freeman, thank you. The court, any other matters today, gentlemen? Attorney Kratz, nothing for today. Thank you, Judge. The court, all right, I'll see you tomorrow at 8:30. Court stands adjourned at 2:42 p.m.